Clarence Earl Gideon stood alone in a Panama City courtroom in June of 1961, charged with breaking into a pool hall and stealing coins from a cigarette machine. It should have been the easiest request he made all day. He turned to the judge and asked for a lawyer, the way anyone facing a felony charge today would simply assume was automatic. A public defender already waiting at the table before the trial even begins. The judge told him, no. Florida only appointed lawyers to defendants who might be executed, and Gideon was not one of them. So he was told to defend himself alone against a state that had its own lawyer standing a few feet away. What that actually meant, researchers would later calculate across a full century of trials, was not a disadvantage. It was closer to a verdict already decided before the trial began. Defendants who had a lawyer were acquitted in 56 out of every 100 cases. Defendants without one in 28. Walking into that courtroom with no counsel did not tilt the odds against you. It nearly sealed them, cutting your chance of walking out free by roughly half before a single witness had even been called. There is an old phrase for the kind of gap that opens up between a person with resources and a person without them in a courtroom. Centuries before Gideon, it was called the neck verse, and it decided who got a second chance and who did not. To understand why a poor man in 1961 Florida was still standing in that same gap, you have to go back almost 800 years to a courtroom where the thing that separated the condemned from the spared was not money, not yet, but a single memorized line of scripture. That is where being poor first became, quietly and by design, the same as being guilty. The neck verse belonged to a plea called benefit of clergy, and it began as a genuine church privilege. After the murder of Archbishop Thomas Becket in 1170, King Henry II conceded that ordained clergy accused of serious crimes could be tried in church courts instead of the king's courts, where punishments were far gentler and executions were rare. For a while, this meant exactly what it sounds like: an actual priest in actual clerical dress claiming an actual exemption. But English courts needed some way to verify who counted as clergy, and by the 1300s, they had settled on the simplest test available. If you could read, you were assumed to be educated enough to have taken religious orders, whether you had or not. The passage chosen for the test was Psalm 51, verse 3, opening with the words, "Have mercy upon me, O God, according to your loving kindness." A defendant stood in the dock, was handed the text, and read it aloud in front of the judge. Pass, and your case moved to the lenient ecclesiastical court. Fail, and you face the full weight of secular punishment, which for a great many offenses meant the rope. People started calling it the neck verse because reading it correctly could save your neck. Picture the scene as it actually played out. A room full of onlookers, a judge waiting, a single sheet of text held out to a man who had perhaps one chance to prove out loud that he belonged to the class of people worth sparing. It worked exactly as designed for those who had access to any kind of schooling. The playwright Ben Jonson invoked it in 1598 and walked away from a manslaughter charge with nothing worse than a branded thumb. Grammar school education in medieval England was rare and tightly controlled, available mainly to boys destined for the church or to families who could pay for it. So the neck verse, in practice, sorted defendants by exactly the kind of privilege that had nothing to do with guilt or innocence. A literate poacher could recite his way to mercy. An illiterate laborer accused of the same offense could not. The failure of this system did not happen quietly, and it did not happen to a small number of people. The overwhelming majority of the accused in medieval and early modern England could not read at all. For them, the neck verse was not a loophole. It was a door that simply did not open. Some offenses were eventually declared unclergyable entirely, meaning no reading test could save you regardless of your literacy. But for the ordinary run of felonies, the pattern held for centuries. Wealth and education bought a second court, and poverty bought the first one, with its harsher sentences and its higher gallows. Even when the Crown tried to close the obvious cheat, branding a defendant's thumb after a first successful plea so the trick could not be repeated, it never addressed the deeper problem. The test was never really about religion by the 1700s. It was a literacy checkpoint standing in for a wealth checkpoint. And the poor kept failing it in the exact numbers you would expect. By the time Parliament finally abolished the reading requirement in 1705, and the benefit of clergy plea itself in 1827, the underlying problem it exposed had already taken a new shape. Because the moment the neck verse stopped mattering, English law had already built a second, far more direct barrier between the poor and a fair hearing, one that had nothing to do with reading and everything to do with a single hardened rule. That rule said a person accused of a felony was not permitted to have a lawyer speak for them in court at all. This prohibition had been standing since at least the 1400s, and by the time it reached its fullest and most rigid form, English judges enforced it without apology. Sergeant William Hawkins, whose treatise on criminal procedure dominated legal thinking well into the 1700s, explained the reasoning plainly in 1721. Any defendant of common understanding, he wrote, could defend himself as properly as if he were the best lawyer available. Judges leaned on a convenient fiction to make this sound less brutal than it was, the idea that the court itself acted as counsel for the accused. In practice, this meant a judge would step in to catch an illegal procedure or a faulty indictment, but it never meant a judge would help a frightened, uneducated defendant build an actual defense, question a witness with any skill, or construct an argument for the jury. The court was there to police the rules of the game. It was never there to play for your side. Stand for a moment in the Old Bailey as it actually operated through most of the 1700s. The accused stood in the dock, often having heard the charges against them for the first time only days before, and was expected to personally cross-examine the Crown's witnesses, respond to the prosecution's paid lawyer, and address the jury unaided, all while the machinery of the state stood fully represented on the other side. This was not a rare hardship reserved for the unlucky. It was the ordinary experience of a felony trial for anyone without money, which was most of the people who stood there. The clearest documented failure of this system belongs to Simon Fraser, Lord Lovat, tried for treason in 1747 at the age of 80. Denied counsel under the very rule Hawkins had defended a generation earlier, Lovat made a direct appeal to the House of Lords that survives in the parliamentary record. "If you do not allow me counsel," he told them, "it is impossible for me to make any defense by reason of my infirmity." An old man alone telling the most powerful legislative body in the country that his own frailty made self-representation a physical impossibility, not merely an unfair inconvenience. The Lords were unmoved. Lovat was convicted and executed, the last person in Britain to be beheaded, and his case would be cited nearly a century later by the very reformers trying to end the rule that killed him. What makes this failure sting even harder is what was quietly happening at the same time, just out of official sight. By the middle of the 1700s, courts had begun tolerating something the law never formally sanctioned. Wealthy defendants hiring skilled advocates like William Garrow and Thomas Erskine, who developed the aggressive cross-examination techniques that would eventually define the adversarial trial we recognize today. The rule against counsel had not changed on paper, but in practice, a defendant with money could increasingly buy access to exactly the kind of skilled representation that the rule claimed was unnecessary for anyone. Poverty had stopped being merely a disadvantage inside the system. It had become the entire difference between two systems operating in the same courtroom, one unofficial and improving for those who could pay, and one frozen in place, in Hawkins's own words, for everyone else. This contradiction could not hold forever, and by the 1830s, it had become impossible to defend in public. In June of 1836, the House of Lords debated a bill to finally grant felony defendants a formal right to full legal representation. The argument that carried the day was almost embarrassingly simple. England and Ireland stood alone among the civilized nations of Europe, and alone against their own colonies and against the United States, in denying defendants the right to a lawyer on matters of fact as well as law. Reports from British colonial administrators noted that allowing counsel for prisoners abroad had produced no disorder, no collapse of justice, nothing but fairer trials. If the rest of the civilized world managed this without catastrophe, the Lords were asked, what exactly was England protecting by refusing it? The Prisoners' Counsel Act passed that year, and for the first time in the history of English common law, a person accused of a felony held the formal right to be fully defended by counsel, examining witnesses, addressing the jury, and mounting an actual defense rather than merely surviving a prosecution. Judges who had spent entire careers inside the old rule did not welcome the change easily, and the legal historian C.C. Griffiths has documented how unevenly the new right was actually exercised in the years right after it passed. But the principle itself had shifted permanently. A felony trial in England would never again proceed on the assumption that an accused person, alone in the dock, was simply expected to manage. It would be satisfying to end the story there, with a single act of Parliament closing a gap that had opened 800 years earlier with a memorized psalm. It does not end there, and pretending otherwise would betray everything the neck verse first revealed. The economist Brian McCannon and his co-author studied criminal trials across 19th century London and found something the 1836 reform never fixed. Decades after the Prisoners' Counsel Act passed, fewer than half of defendants charged with serious crimes actually had a lawyer standing beside them in court. The act had granted a right. It had never provided the money required to use it. A poor defendant in 1861 England was, on paper, exactly as free to hire William Garrow's professional heirs as a wealthy one. In practice, he could not afford to. The same pattern crossed the ocean and outlived the century. Australia introduced a groundbreaking federal law in 1903, allowing impoverished defendants accused of any federal crime to apply for legal representation, followed over the following decades by Poor Prisoners' Defense Acts across its states. Researchers tracking representation rates found that even a full century after the original English reform, somewhere between a quarter and a third of defendants facing serious prison time still went to trial with no lawyer at all. The gap the neck verse had first exposed in the 12th century, the one that sorted defendants by what they could produce rather than what they had done, had never closed. It had simply changed its currency. Where it once asked whether you could read a line of Latin scripture, it now asked whether you could afford an hourly fee. Being poor had never stopped functioning, in practice, as a kind of quiet verdict of its own. That is the gap Clarence Gideon fell into on an ordinary morning in 1961, more than a century after England had supposedly solved this exact problem, and more than 800 years after a Latin psalm first proved that literacy, or its absence, could decide a life. American law had inherited England's old common law rule, and largely abandoned it in principle by the time of the country's founding. But the actual right to a government-paid lawyer for the desperately poor had never been settled by the Supreme Court for state trials, only for federal ones. Gideon, convicted and sentenced to 5 years with no one to represent him, did the only thing left available to a man with no money and no law degree. He went to the prison library and he wrote. Using a pencil and lined prison stationery, he drafted a 5-page petition to the United States Supreme Court, filing it in forma pauperis, the legal mechanism that lets someone too poor to pay court costs bring a case anyway. Out of the thousands of handwritten petitions the court receives in a given year, the justices chose to hear his. On March 18, 1963, the court ruled unanimously that the right to counsel was fundamental and essential to a fair trial, and that no state could deny it to an indigent defendant facing serious criminal charges. Justice Hugo Black, who had dissented from the opposite ruling 2 decades earlier, wrote that lawyers in criminal courts are necessities, not luxuries. Roughly 2,000 prisoners in Florida alone were released or granted new trials as a direct result. Gideon's own retrial took place that August, 5 months after the ruling, in the same Panama City courthouse where he had once stood completely alone. This time, a local attorney named Fred Turner sat beside him, and Turner spent the trial quietly picking apart the testimony of the prosecution's key witness, exposing inconsistencies that had gone entirely unchallenged the first time around, when no one had been there to challenge them. The jury deliberated for about an hour. Clarence Gideon walked out of that courthouse a free man, roughly 2 years after he had first asked a judge for exactly the thing that finally set him free. Look back across the whole distance from that Latin psalm to that pencil petition, and the through line holds steady the entire way. A medieval court decided who deserved mercy based on whether a man could read a verse he likely never understood in a language he never spoke at home. An 18th century court decided a defendant of common understanding needed no help at all, right up until wealth quietly proved otherwise, for anyone who could afford it. A 19th century parliament granted the right to a defense and then left the poor to discover that a right without money attached to it is barely a right at all. And it took a 50-year-old drifter with an 8th grade education, writing in pencil from a prison cell because he had absolutely nothing left to lose, to finally force a government to pay for the lawyer itself, rather than simply permit one to exist. If you had been standing in that Panama City courtroom in 1963, watching an hour of jury deliberation after 2 years of fighting completely alone the first time around, what do you think was actually running through Gideon's mind while he waited? If you made it this far, you clearly liked it, and a subscribe would mean a lot. See you in the next one.